Okay, so part two of the federal court system. We're going to be looking at the process of the Supreme Court, how cases get there, what happens after they get there, etc. Then we'll be looking at some of the important key players in a Supreme Court case, and we'll look at judicial philosophy. So, getting right into it, process of the Supreme Court. A case will come to the Supreme Court and will be taken up by the Supreme Court when the court issues what is known as a writ of certiorari. And this is an agreement of the court to review a case. So they will issue this what is sometimes just called cert, and certiorari is a Latin term which means to make certain, because ultimately that's what the Supreme Court is doing. They are making certain that it is in agreement with precedent, is in agreement with the Constitution of the United States of America. And so what occurs in order for a writ of cert to be ordered is there must be a vote of 4 of the 9 justices to agree to review a decision of a lower court. So notice it's not even a majority. It's 4 of 9. And so in order for a writ of cert to be ordered or to be issued, the case must meet Rule 10 of the Rules of the Supreme Court. And Rule 10 says cert is not a matter of right, but is to be granted only when there are special and compelling reasons. This can include conflicting decisions between circuit courts and state courts of last resort, conflicting decisions by 2 or more state courts of last resort, cases that address civil rights or civil liberties, and cases in which the federal government is an appellate. So it has to fit into one of those categories. It can't just be on a whim. It must meet one of these criteria outlined in Rule number 10. Only about 1% of the cases appealed to the Supreme Court actually make it to the Supreme Court. They only take up about 1%. And that's being generous. There's fewer than 80 cases that they take up a year and that they decide in a year, and it's typically more around the 60 mark. After a writ of cert is ordered, preparation will begin. Attorneys on both sides will submit their briefs. They'll submit their written documents. These written documents may be several hundred pages long, and they explain their cases, and they use precedent in order to try to sway the Supreme Court justices in their direction. And sometimes there will be what is known as amicus curiae, which is Latin for friend of the court. Amicus curiae are individuals who are not party to the case, but submit information as a, quote, friend of the court. These could be experts with expert testimony or interest groups that are trying to get the court to decide one way or another. After preparation is done, oral arguments will be held. Attorneys on both sides will appear before the court to present their positions and answer questions. Each side only gets 1/2 an hour to make their case and to field questions from justices. So it's going to be very succinct. Your your briefs that you've submitted may be very, very long, but your oral arguments are 1/2 an hour, and that includes questions from individuals on the Supreme Court and Supreme Court justices. Following oral arguments, a conference will be held. On Wednesdays and Fridays, the Supreme Court has their conferences. These are strictly private meetings with no outsiders permitted. This gives justices the opportunity to speak freely with one another. They discuss the case and eventually reach a decision on the basis of a majority vote. So in the conference, this is when they're going to come to their decision. This is when they're going to hash it out. They're going to talk about it, and they're going to be able to talk freely within their conference because there are no television cameras or recording devices or outsiders. It's just the 9 individuals in that court. They've read the briefs, they've listened to the oral arguments, and now they have to come to a decision. Following the conference, following a decision, opinion writing will occur. So after the decision is reached, one member of the majority will be assigned to write the majority opinion. So the majority opinion is going to be written by a certain individual. If the Chief Justice is a part of the majority, he will assign the writer of the opinion, right? So if he is with the majority, he's going to say, you in the majority will write this opinion. If he is not in the majority, if he is in the dissent, the most senior member of the majority will make that assignment. So whoever's been on the Supreme Court the longest will decide who writes the majority opinion. They write what the court's decision is, they write how it was determined, and they write what precedent is based upon. Remember, precedent is looking at former cases that have been decided and making sure that these cases are in line with those prior cases. Sometimes members of excuse me. Sometimes members of the majority will agree with the opinion, but they will differ in why they agree with the opinion. And so they will author a different rationale or emphasis in the majority opinion. They'll write what's known as a concurring opinion. So they're still in the majority, they concur with the majority, but they just have a little bit of a difference. They're going to tell why they believe it should be this way. There will also be the dissent. So there will be a majority, there will be typically a dissenting opinion. Justices who are in the minority, in the dissent, I'm sorry, my notes aren't making sense. Justices who disagree with the majority decision may choose to publicize their disagreements in the dissent. So they might write their own dissenting opinion, counter to the majority, saying this is why we voted the way that we voted. This allows for reasonings of the case and why they voted in a particular manner. And so this is going to be the case, and typically we're going to see the Supreme Court release their decisions sometime in June before they recess for the summer, and then they begin their term again, their next term sometime around September or October, and in that interim they're obviously vacationing, but they're also riding the circuit. Remember, they are assigned to an appellate circuit that they oversee. They're riding the circuit. They're taking part in other cases as well. But this is basically the process of the Supreme Court and how they come to a decision. Key players. Obviously, you've got the justices. Now, there are no constitutional qualifications for who should be a justice. You do not even have to be a law school graduate to be a lawyer, but you must be trained in the law in some way. And this makes sense because back in the day, it wasn't as common for people to go to law school and get a formal education in law. They would study as an apprentice or by themselves and challenge the bar and become a lawyer in that manner. And so, as long as they have some kind of training in the law, then they are free to be appointed as a justice of the Supreme Court. Solicitor Generals are significant players. They are the third ranking official in the Justice Department. And if you think back to that, when we talked about Robert Bork, he was the Solicitor General in the Nixon administration. This individual is the top government lawyer in all cases before the Supreme Court in which the government is a party. Half of the Supreme Court caseload is under the charge of the Solicitor General. And so the Supreme Court will give very special attention to how the Solicitor General shapes an argument, because they do wield a significant amount of power in regards to what they argue in front of the Supreme Court. And then there are law clerks. I'm having the troubles here. All right. Then there are law clerks. Every federal judge employs clerks. Law clerks do research on legal issues, and they help to prepare opinions, and every Supreme Court justice is assigned 4. Typically, a law clerk is going to be an honor graduate from a top law school. Clerkships are very prestigious, and they indicate individuals who are likely to rise to the top of the legal profession. So they're going to be individuals that will probably go on to become Supreme Court justices themselves, become high-powered individuals in law, be attorney generals, etc. Typically, not just any run-of-the-mill law student will become a law clerk for a Supreme Court justice. It's going to be a very coveted position, and they're going to be sort of the cream of the crop there. Judicial philosophy. There is an argument as to how what philosophy should be applied to the judicial system. And there are a couple of different types of judicial philosophy. There is judicial restraint and there's judicial activism. There are individuals who believe that everything should be applied to the everything should be all things in government that are passed, all these laws, should not go beyond the Constitution. Okay? The clear words of the Constitution. There should be very little interpretation, if any at all. And so these individuals are typically known as strict constructionists. They think that what you see is what you get. The Constitution is written, it spells it out. This is what needs to be done. Laws should not go against what is written here. We're not going to interpret anything. We're not going to stretch anything. This is it. And then there are judicial activists. And in judicial activism, it's the belief that the court should go beyond the words of the Constitution or the statute to consider the broader societal implications of its decisions. The idea is that this document was written 200 plus years ago, and it is a living document, and so changes sometimes have to be made. Interpretations sometimes have to be made, and they feel like they should expand the interpretations of the Constitution when they feel that it is socially desirable. And so if over the course of our 200 years, society has shifted in their belief in something from the time it was written to modern day, there's going to have to be some new interpretation. We cannot use the same old stale document that was written 200 plus years ago, or that's the idea of a judicial activist. And so they believe that interpretation is necessary so that the Constitution can be applied to modern day. Because let me tell you folks, we are incredibly different than we were 200 plus years ago when the Constitution was written. And there are certain things that face the nation today that never, ever, ever could the Founding Fathers have ever thought about and made preparations for. And so judicial activists really feel like there needs to be some expansion of the interpretation. Sometimes we see political philosophy, conservatism versus liberalism associated with these. A lot of time judicial restraint is associated with conservatism. A lot of time judicial activism is associated with liberalism. But that is not always correct. And so sometimes these are going to be used interchangeably. Sometimes they're going to be confused with conservatism and liberalism. And sometimes we will hear the media say those liberal activist judges. Well, yes, liberals can be activist judges, but so too can conservatives be activist judges. And one great example of a conservative activist judge was William Rehnquist, who was the previous Supreme Court Chief Justice. He was an extremely conservative individual, but he was active in interpreting the Constitution in new ways to fit that conservatism. And so just because you are a judicial activist does not necessarily mean you are a liberal. It just means that you interpret the Constitution in new ways to sort of fit your view of the Constitution. So don't get that confused. And then this last slide, just some fascinating information about the Supreme Court. The first African American to be appointed to the Supreme Court is Thurgood Marshall. And he's going to be nominated by Lyndon Baines Johnson. He will be approved. He's going to be the first African American. The first woman on the Supreme Court is going to be nominated by Reagan. It is Sandra Day O'Connor. And the first Hispanic on the Supreme Court is going to be nominated by President Obama, and that is Sonia Sotomayor, who currently sits on the Supreme Court. Eisenhower, there's a funny story about Eisenhower, and he is going to appoint a couple of people to the Supreme Court, and at the end of his presidency, some reporter or someone interviewer or something like that is going to ask him if he has any regrets regarding his presidency, and he says yes, and they both sit on the Supreme Court. Because sometimes presidents will nominate somebody because they believe them to be a conservative or a liberal, or in line with the president's political views. And when they get on there, they're on there. They're on there for life. And so they sometimes not confuse, but they sometimes will astound their nominator because they start interpreting things a little bit differently. And so that's kind of a story about Eisenhower in particular. There are only 3 presidents in American history who have not appointed a Supreme Court justice. Number 1 was William Henry Harrison, and that's because he served 1 month before he died. I believe he was the 9th president. He died after 1 month in office, so he didn't have time to appoint a Supreme Court justice. The second one was Andrew Johnson, who was the 17th president, who took over after Lincoln was assassinated. He never appointed anybody to the Supreme Court. And interestingly enough, the third one was Jimmy Carter, who was the 39th president and only served 1 term in office, but he did not have the ability to appoint anybody to the Supreme Court. Every president since George H.W. Bush has appointed 2. So if you think about George H.W. Bush appointed 2, Clinton appointed 2, W. Bush appointed 2, Obama appointed 2, and now Trump has currently appointed 2. George Washington appointed 11. Obviously, it's the founding of our nation. They're going to act understand that there were fewer people on the Supreme Court back then, so he appointed a lot of people. FDR appointed 9, Taft appointed 6, and Reagan was able to appoint 4. William Howard Taft, he's going to be the only president to go on to become a Supreme Court justice. So Taft is going to be the president of the United States. He is going to serve as the president, but he always wanted to be a Supreme Court justice. And so after he leaves office, he will become a Supreme Court justice. He will actually be appointed as the Chief Justice by President Warren G. Harding. So that's just a little bit of interesting information. Okay, so that's going to conclude our lecture series on the federal judiciary. As always, feel free to give me a holler if you need anything or if you have any concerns. And so I'll be seeing you in the next lecture series. Thanks.